Mr. Mutaung, I'm sitting slightly with my back towards you, and it's not out of disrespect or anything. I'm just trying to work on my laptop, and I've got some of these microphones in my space. So please excuse me for doing that.
That's understandable, Your Worship. I must also indicate that it feels a bit awkward that I'm standing on the other side of the fence. I hope this would not really go down to even impact on my address, but I still appear on behalf of the applicant, Your Worship.
Thank you.
Your Worship, I think what one is required to do in this bail application, take into account that this is a continuation from the address that was presented by Advocate Dlamini on the 30th of August 2023. In avoidance of regurgitation of some of the aspects which were eloquently articulated and dealt with by my learned colleague, one would just to have a structure and framework of my address, point out salient issues emanating from this address of my learned colleague. Your Worship, you would note that our address commenced with the preliminary issues. Now, I intend to address the court under the following topics. My learned colleague dealt with preliminary issues pertaining to the schedule. I'm not going to delve deeper into those issues, except to say, in the light of the notice that has been dispatched by the DPP's office, I'm inclined to provide a brief response thereto. Your Worship, the next topic that my learned colleague dealt with related to the charges preferred against the applicant, and he then further dealt with the topic around the state's case, and he spent quite some time dealing with the issues emanating from the state's case. From time to time, Your Worship, I would piggyback on some of the issues emanating therefrom. The topic that I will address this court on will be the applicant's case, and thereafter I will address the court on the absence of the provisions of section 60 subsection 4 A to E. So in essence, I'll deal with bail legislation in respect of this matter. Your Worship, I will then move to deal with the applicable law, inclusive of case law, in demonstrating to this honorable court that the interest of justice exists in this matter, and that the state, in its opposition of the applicant being released on bail, did not establish any of those factors as delineated in the in section 64 A to E. Your Worship, the background details in this matter and the germane facts in this matter are quite straightforward. The applicant approached this honorable court with an application for her release on bail. She deposed an affidavit by demonstrating to this court various factors that would show that the interest of justice permits the release of the applicant on bail. I would like to zoom into some of these factors emanating from the applicant's affidavit. I will demonstrate to this court that these factors, until now, and some of those, have not been sufficiently, if at all, being addressed nor undermined by the state in opposition of bail. Your Worship, the affidavit, among others, touched on personal circumstances of the applicant. Now, this point is quite crucial when determining the suitability of the applicant to be admitted to bail. All the factors in her affidavit in respect of personal circumstances remain but undisputed. Now, it's tried law that where evidence remain undisputed, that evidence automatically should be accepted by this honorable court. My submissions are that the evidence, in as far as personal circumstances are concerned, it's not even riddled with any improbabilities. It's not far-fetched, succinct to the point that the applicant has strong family ties within the area where she resides, including strong family and occupational ties in the Republic of South Africa. Now, one will pause and check the affidavit by the state in opposition of bail and try and locate any aspect from the state's opposing affidavit which negates this very essential element of the applicant's case. It goes without saying, Your Worship, that there is nowhere in the opposing affidavit where this issue is being attacked by the state. Your Worship, we will then move to the travel documents. It's also a point that is common cause, that the applicant's travel documents have been confiscated. Her passport, according to her evidence, was confiscated. Now, what is the relevance and essence of this assertion? The relevance, Your Worship, I submit with respect that it touches on the very vein of section 60 subsection 4b, that should the applicant be released on bail, is there a likelihood? And by the way, the inquiry there is not just merely a likelihood of the applicant for bail evading trial, but the likelihood that the applicant will attempt. And I'm saying this with emphasis. It is therefore incumbent on the state to produce evidence and not merely speculate, produce tangible evidence to the effect that there is a likelihood that the applicant will attempt to evade her trial. In this instance, Your Worship, the applicant made it quite clear, played open cards to this honorable court, that I have travel documents, but it has been seized. But it does not even end there. My learned colleague eloquently put forward a point that is crucial for the determination of this aspect. To say the state in its own opposing affidavit indicated how the applicant has been traveling in and outside the Republic of South Africa, coming back with no issues whatsoever. So even in the most extreme of cases, should it be found that the accused had a passport, could have been the accused would readily surrender such passport. But in this instance, the accused's passport the applicant's passport is confiscated. Now the question here, crisp question around this issue, is whether or not the accused has any other business to do or deal with outside the Republic of South Africa. And to this end, the applicant has not adduced such evidence, neither did the state in its opposition of bail adduce evidence to the effect that the applicant has some interest outside the borders of the Republic of South Africa. Your Worship, the applicant's family background has been placed on record through the affidavit. Even then, this evidence is not disputed at all. In actual fact, to lower the bar a bit, it's not challenged. The state has simply accepted the background details of the applicants with regards to her family being living in Port Edward, having 3 siblings. All of those facts were not just facts that are placed on record as evidence without any basis. The basis of us placing these facts in the affidavit simply to demonstrate to this honorable court that the applicant has strong family ties within the Republic of South Africa. The issue of the assets also features in the affidavit of the applicant. She indicated there the type of assets that she has. This augments the applicant's case to a large extent, mindful of the fact that the criteria can never be that anyone without assets might find him or herself on the back foot. But the reason why we mention the assets, particularly movable assets, by the way, movable assets to the value of R1 million, that is quite a substantial amount. Now, this aspect touches sharply the vein of Section 60, subsection 4B, in respect of whether or not that risk, that likelihood of an attempt to evade trial is completely diffused, because the inquiry should be, can the applicant afford to lose these assets? I will pause here with regards to this, because it's a point that one has to deal with it holistically, zooming into the argument by the state, to the effect that the applicant has everything to lose, particularly on the strength of the state's case. The state is saying Section 64, pardon me, Your Worship, Section 64B finds applicability here on the basis of the state's case being strong. By the way, Your Worship, this appears from the state's opposition of bail to be the only ground that the state presents to this court, the ground that the state is of the view is demonstrable of the likelihood existing. Now, at a later stage, I'm going to illustrate how some of the concerns could be cured, and this will be cured in terms of our own legislative processes. Legislation is mindful of some of the concerns that would arise in respect of admitting an applicant to be released on bail against the backdrop of a fear or concern that the applicant may attempt to evade his or her trial. My submissions are, Your Worship, that when we zoom into Section 64B, that we need not only look at this factor of the state in isolation, that my learned colleague pointed out assortment of anomalies emanating from the state's case. If the state's case, or if the state's submissions is to the effect that they have a strong case, my learned colleague has dealt the state's case a blow by listing a myriad of factors pointing out the shortcomings in the state's case. I would sufficiently, as I deal with case law and legislative provisions, I'll sufficiently deal with this aspect from the state's case. Your Worship, the applicant in her affidavit indicated that she does not have previous convictions, neither does she have any pending cases. This is quite crucial. This is quite crucial because this aspect, Your Worship, largely touches on the provisions of Section 60, subsection 4A, the propensity to commit further offenses if admitted to bail. And that's a likelihood, by the way. Your Worship, we need not delabor on this point any further. We need not overburden this court in respect of this aspect. We will take it that by law, this is a legal position and there is no two ways about it. The assertion with regards to registered cases has been dealt with by my learned colleague. But I must indicate that the bearing thereof, if there is any, of the some other cases being investigated, that would not have any bearing whatsoever in respect of this application. Before this court, applicant has no previous convictions. Before this honorable court, the applicant has no pending cases. That's the end of the debate. We can't take it any further. Any desperate measure of trying to take those issues out of so-called registered cases is but unhelpful to us. Your Worship, there is also a mention of civil case. At what point do we even argue pending civil case? At what point do we even argue judgment of a civil court having a bearing on proceedings of this nature? But I will take it further, that the applicant has pursued a civil route to challenge the lawfulness and unlawfulness or otherwise of her apprehension in Tanzania. That's common cause fact. It's also common cause that the tried law, by the way, that the results, the cost follows the result. But the state comes to this court, also mentions the approximate amount of cost incurred this far. Must indicate that I find no relevance of that, particularly when we know, in terms of the civil processes, that a bill will be drafted, it will be presented to the taxation master for taxation purposes, and all those processes must be observed. But the relevance of that, could it be that all these are mentioned, issues are mentioned, the ones that I've pointed out, they are mentioned simply to cause an embarrassment on the person of the applicant? Because if I find no relevance in those submissions, there should be some way to try and analyze the rationale behind mentioning those. I respectfully submit, Your Worship, that until now, I have demonstrated to you that the evidence as presented by the applicant remains unchallenged. Now, Your Worship, there is a paragraph in our affidavit which can be located in page 8 thereof. And this paragraph deals with circumstances around my departure from South Africa. To this end, what we have here is the applicant for bail delineating to you her departure from South Africa. And the point that she is driving home is that I did not depart from this country voluntarily. And, Your Worship, she is saying, I am mindful of my right to remain silent. By the way, it's a crucial right in proceedings of this nature, including in criminal proceedings. It's a crucial right, the right of the applicant to remain silent. But she is saying, I'm taking this court into confidence to the extent that I just have to illustrate to this court the circumstances flowing from my departure from South Africa. Brief as it could be, but it does not negate the fact that she departed from South Africa involuntarily so. Now, anything to the contrary is but casting aspersions. Anything to the contrary is but trying to zoom into the rationality of the, or probability rather, of this version. Now, the state, in trying to rebut this, and I'm saying in trying to rebut this because I'm saying so deliberately, because it doesn't come out clear whether the state really rebuts this version and puts another version. Because then it will have come to this court succinctly that, wait a minute, you allege to have involuntarily exited the borders of South Africa, but we have on good authority that this and that happened. But what the state then attempts to do is to say, look, how could it be possible that you could involuntarily depart, and whilst there you crossed other borders or you came across other people? Couldn't you have issued SOS to the effect that I have a problem here? They take it further to say, couldn't you, by the way, there is a tracker which confirmed you being in KwaZulu-Natal with Thabo Bester shortly after the escape. Still not sure, perhaps the state they might have a sophisticated technology in terms of that tracker, but it didn't come out clear or come out at all from their evidence that the tracker showed the applicant's face, placed the applicant on the scene. It's merely about what I will term circumstantial, if I have to go there, circumstantial, that this is a vehicle belonging to the applicant. The only inference, I wouldn't say reasonable, an inference that can be drawn is that it was driven by the applicant. They furthermore downloaded some images. My learned colleague dealt with that. Obviously, the provisions of the Electronic Communications and Transaction Act, ACTA, are quite very clear in terms of reliance on video material, reliance on images that are to be used, and the procedure that has to be followed in order to have evidentiary weight. Not only that, Your Worship, but to also have such evidence admissible in court as evidence. What we have is pictures of people sitting, looking at each other. Is two pictures. The reason the state is resorting to that strategy is simply to undermine the allegation that I involuntarily left the country. Your Worship, the state's approach there is problematic. Problematic in that this is a space and zone of experts, by the way, in as far as the reaction of the applicant is concerned. Surely we don't have any form of expertise to even interpret someone's reaction and to be conclusive in terms of how a person could have reacted in a particular circumstances. Those factors are unknown at this moment. Hence, the defense, we actually find it very problematic that you can create those insinuations that according to the investigating officer, he signed out from his evidence by indicating the distance between South Africa and Tanzania. He leaves us second guessing the purpose. Could it be that they want to show this court the distance traveled? They take it further to say and draw some comparison that the accused number 5, having landed back into South Africa, later on laid charges against the state for lost items. Why could you not have done likewise? That's the question posed to the applicant. By the way, I'm making this submission, Your Worship, with respect, that our law in proceedings of this nature, or rather to rephrase, in criminal proceedings, or rather in terms of criminal law, there are certain crimes, or most crimes, which are not time bound. And this would lead me to prescription, among others, consideration of prescription. Can reporting of crime prescribe? You failed for 4 months to report this offense. Could it have any bearing? I'm just assuming that there will be a case, assuming, and I'm not saying that that will be the issue, because it is the prerogative and the direct prerogative of the applicant in respect of what do I do now. She decided how she decided it. The question that should arise out of this debate is whether or not this aspect has been undermined. And the answer thereto is a big no. The allegation, or rather the evidence by the applicant, has not been undermined to the extent that how she exited the boundaries of the Republic of South Africa. Your Worship, the evidence of the applicant, furthermore, on page 9, this deals with salient factual background on her arrest. Now, the state seems to be having a problem in the avenue explored by the applicant in challenging her unlawful disguised extradition to South Africa. By the way, it's a high court ruling. It's a high court ruling, part of which is still under litigation, sub judice. But the point I want to drive here, Your Worship, is that the applicant was brought to this country in the manner that has been delineated expansively in the application before higher courts. But she remains in custody from the 13th of April to date at Bizamagate Correctional Facility. Now, the relevance of this evidence is that the applicant has spent a long period in detention. And I will demonstrate later on in my legal arguments that the reason for her to still be in custody cannot be attributed to her fault or fault on her part. But that being the case, the test here has to do with the fact that the applicant, or rather the state's case, is still under investigation. So the applicant did not play any role in the delays in finalizing in the finalization or conclusion of the investigations. So where the applicant is that she is still pending, or rather the case is still pending. Investigations have not been completed. We don't have an indication how far the investigations will go, other than that on the 11th of October 2023 the state would have concluded the investigations, which would have to then deal with issues of trial, pre-trial issues, which by the way would take a while. So in essence, what we are saying is that the period envisaged for the matter to commence should be taken into cognizance when we determine this application. That the applicant, by the way, Your Worship, has a right to liberty in terms of Section 12 of the Constitution. Obviously, there is caveat linked to that, and I will address the court on those aspects at a later stage. Then, Your Worship, you will turn to page 10. Page 10 dealing with charges. Now, when we get to this stage, I am inclined to revert to the earlier preliminary submissions made in as far as the schedule of this offense is concerned. Your Worship, the defense and the state were ad idem in as far as the schedule of this offense is concerned. And this was based primarily and exclusively, by the way, on the charges that the state presented to the defense. The state, Your Worship, presented charges showing, among others, as indicated eloquently by my learned colleague, that Mr. Dlamini, that there is a count, it's a count 3, which dealt with the amount involved, and this is a count of corruption, and it related to Teboho Daniel Dipolo. The amount involved is 2.5. Then the state also in count is, I think count 4 does not include accused number, the applicant, and it's settled. It's not, she is not here in terms of count 4. Now, it is on the basis of this count that we acceded to the scheduling of the offense under Schedule 5. Now, the state, after hearing our submissions, obtained a notice confirming the schedule from the DPP's office. Now, I want to take this position. There is evidence before this court. Evidence in opposing bail by Captain Flyman, who packaged these counts, stated the amount involved in count 3. And in count 3, Colonel Flyman refers to an amount of 85,000. Your Worship, we can peruse and peruse and peruse this affidavit. Will never find an amount of 2.5 million. We will never find it. Now we have this as evidence, and we have a charge sheet saying something else, and we have a confirmation from the DPP's office which deviates from the evidence. So we find ourselves seated between two versions. Actually, between one version and some submissions somewhere. Because this is a version, this is evidence. The opposing affidavit is evidence. Is what the state has. The charge sheet is what the state promises us. State is saying, when we commence this matter, we will have this. But for now, I have something else. Otherwise, I just need a more plausible legal reasoning for this disjuncture. Because to me, there is a disjuncture. Now, I submit with respect that the confirmation by the DPP will not cure this deficiency. It does not have any effect to cure it. The deficiency is incurable. So, according to our to the charges, we have just placed the charges without mentioning the amounts. So I take it that even the state placed the charges and placed the amount, and those amounts should be admitted as evidence, and anything to the contrary will not have evidential weight or evidentiary weight. Your Worship, the applicant presented legal arguments in
Just interrupt you at this stage. I don't want to take you offline where you're busy with. I need you to just explain what you're saying to me again. I'm looking at count 3, the allegations in count 3 is against accused number 1, 2, 3, 4 and 5, and it is contravening section 3B, reading with other sections, prevention and combating of corrupt activities, and it says on the 14th of April, in the furtherance of common purpose, the accused unlawfully and intentionally directly gave or agreed or offered to give to any other person gratification. They offered him 2.5 million but only paid him 40,000 to assist with the disconnection of the cameras. That is the allegations in count 4.
In count 3, Your Worship.
Count 3 against accused number 4, applicant number 4.
Yes.
And then if I look at the written confirmation by the DPP that was handed in today, it also refers to that the applicant before court will be arraigned on, amongst others, 4 counts of corruption with regard, in brackets, 2.5 million that was offered and only 40,000 and 85,000 was paid, and another 500,000 was offered and only 10,000 was paid. So can you just explain to me where in your argument you said that there's a huge discrepancy? Just make it clear to me, please.
Thank you, Your Worship, and thank you for the opportunity. Your Worship, this is a legal argument that we are making. Against the backdrop of confusion that the state has brought into this bail application. I fully align with this Honorable Court with regards to the counts that have been read out. This is what we also have in our in the charge sheet, except the other counts there that I also knew. I think the last count of 500,000 is not even part of this charge sheet. If this court can microscopically zoom into the charges. Now, where we are, remember that, Your Worship, we found it difficult to refer you to the affidavit of Captain Flyman because it's not numbered. But that is not a problem. I will refer you to that page by pointing out paragraph N at the top of that page. Now, according to, and this is evidence now, this is what we're dealing here with, evidence. What the state indicated, the state can say, I'm going to charge you with assault. And the state proceeds to lead evidence of theft. This is the analogy that I would like to bring to the fore for us to have a better comprehension of the direction we are taking. The posture we are assuming is a posture that says we have evidence before this court. This evidence is saying count 3. It's making reference to count 3, and this is corruption. And it refers to an amount of 85,000. Nothing else. Nothing else. And count 4, we are then referred to count 3 above. As though it's duplication, perhaps changes of names. I don't know. I don't want to address this on behalf of the state. But what I do know is count 3 refers to 85,000 rands in respect of accused number 1. According to the charge sheet, count 3 refers to an amount of 40,000 rands, and it creates an impression that there is an amount of 2.5 million at stake, at play here. The DPP also comes and confirms what is in the charge sheet. Hence, Your Worship, in my earlier submissions, I put a disclaimer to say, much as the state is now presenting this notice, we are saying this should not be misconstrued because they are presenting it. It shouldn't be misconstrued to say it's the same as the charge sheet anyway. What they have in the DPP's confirmatory notice is the same. It's a duplicate of the charge sheet. Now, our argument here is, Your Worship, in what manner can any defects on evidence be cured? Can it be cured through submissions from the bar? Our law is quite clear on that. That should be part of evidence. Evidence must be led to that effect. What we do know is that we have the applicant allegedly having offered or paid whatever the issue is. And this can be located in this paragraph that I've referred to, but it's referred to as count 3. So that is where we are, Your Worship. That this situation ordinarily, and it's inescapable, that it creates a disjunction. We have evidence that contradicts the charge, that contradicts the confirmatory notice by the DPP's office. And there is no explanation there too, in as far as the evidence is concerned. That is where we raised a point in limine in respect of the scheduling of this offense. That this offense, against the backdrop delineated, cannot be said to squarely fall under Schedule 5. But this is Schedule 1. Now, in our address, because, Your Worship, the submission was not made as a form of an interlocutory procedure where we would want this court to make a ruling before we move on. Now, the approach is we are proceeding on the basis agreed before. But we are saying, court, please, you should not lose sight of this discrepancy that we uncovered in the state's evidence. That acknowledge that charges an accused with a particular charge, invariably, evidence must be led in respect of proving the elements of that particular charge. Anything to the contrary has got its own effects. So where we are now, we are saying, state, your evidence differs with your charge in as far as this is concerned. I hope, Your Worship, I've sufficiently addressed the issue that you wanted me to do so. In the event that there are still some residual aspects emanating from my submissions, I'm at your service to address those.
Thank you, sir. We made it clear. You may continue.
Thank you, Worship. Your Worship, then our affidavit deals with Section 60. I'll park those because those are the legal submissions. And then final leg of our submissions, that the applicant is a candidate to be released on bail, and we address the amount which is an amount of 10,000. Now, Your Worship, if you allow me, as per my earlier submission, I indicated there that I will be then dealing with the law relating to bail. Now, I think this, to me, is a principle which I consider to be the bedrock of bail applications or bail legislation. The non-penal character of bail. There is our bail legislation and jurisprudence is replete with a whole range of case law in respect of that, and I will deal with some of the cases dealing with that aspect. Now, as a tried law, the applicant cannot be held in custody as a form of anticipatory punishment. And it's settled law. Now, where can we locate anticipatory punishment? My submissions are, we can locate anticipatory punishment through the posture adopted by the state, particularly with regards to the strength of the state's case, that the applicant might have to spend a long-term imprisonment. That argument cannot be loosely presented. And we cannot pay lip service in just absorbing this argument without any measure of interrogation. Now, for us to get to bail legislation, Your Worship, just want to locate this quickly, Your Worship, if you can bear with me. There is a case of State versus Mafe that I would like to refer to. If the court can just bear with me to locate it. I seem to have lost it, Your Worship, your indulgence. If not, I'll revert to this point. It's a very crucial point and it's a very crucial decision. I found it, Your Worship. Your Worship, this is the Mafe versus the state. And the citation on this matter is bracket A49/22, 2022 ZAWCH at page 108. In this instance, Your Worship, Justice Tulare pointed out the following, I quote, "In my view, fairness and justice call for the state to put the substantial facts upon which its charge is founded. First, that will be the first leg, and then the accused has an opportunity to provide an answer and show exceptional circumstances where applicable. And if needs be, the state gets an opportunity to rebut. In that case, a court can be well informed to form an opinion whether it has reliable, sufficient, or important information to reach a decision on the bail," unquote. Your Worship, I'm raising this authority specifically to demonstrate to this court how the state should approach a matter where they base the opposition on the strength of its case. Now, Justice Tulare succinctly point out the position that there must be substantial facts upon which the charge is founded first. My learned colleague, Advocate Lamini, has already showed a lot of issues. So there are conglomeration of factors that in the defense position points toward the fact that we don't have enough at our disposal to deal with this issue. The issue of the charges. But furthermore, mindful of the fact that the applicant exercised her right to remain silent. But the information at our disposal, is it really reliable? Is it sufficient? Is it an important information to enable this court to really arrive at the conclusion? And in this instance, he takes the point further. Justice Tulare takes the point further to say, when we're doing so, I quote, as envisaged in section 63 of the CPA, without infringing on the responsibilities and the rights of the state and of an accused. Now, what we have here, Your Worship, is evidence that is presented by way of affidavits. The state knows as well the probative value of evidence presented in that manner. But such evidence by law is not impermissible. It's more of the probative value. Now, the state is opposing. The state is saying, I have a strong case. And the state has presented a whole range of allegations, some of which, Your Worship, cast doubt, or rather, they are untruthful. There is, for instance, an allegation which I will deal with later, of the number of times the applicant has been in contact with the children. The state comes up with something else, which is not backed up by any shred of evidence. It's their word, and their word cannot be gospel. It's their word to say, she has not contacted her kids except once. Where did they get that information from? Why was it not attached as they went as far as downloading pictures. The state went as far as getting some documents from some other jurisdictions. But information that is pertinent to their case is just left hanging. And it's expected of this honorable court to just accept. Your Worship, I will then move to the next argument, or rather the next point. And in so doing, how I will approach this, Your Worship, is to just give a sketch out without regurgitating what the law says. We know what the law says. We know what Section 64A to E, Section 60, 6, 7, 8A, and 9 prescribes. But what I would want to do is to demonstrate to this court how these requirements of the law fits into our client's facts. So, Your Worship, we can all agree that Section 60, subsection 4A has not been rebutted. So the state has not established the likelihood that if the applicant was to be admitted to bail, that she will commit Schedule 1 offense. They have not dealt with that. In their own affidavit, nowhere has the state dealt with this matter. So we can accept that this provision of Section 64A has not been established. Okay. And now we have a way and a measure of verifying if indeed there exists any likelihood. And in this instance, Your Worship, I must indicate that the fact that the applicant has no previous convictions, has no pending cases, falls squarely under this section. The fact that the state has registered some other cases has no bearing. Now we move to Section 60, subsection 4B, evasion of trial. Your Worship, in this instance, the applicant has already submitted that there is no likelihood that she will evade her trial. Perhaps what we need to zoom into is to check what is meant by likelihood. Is likelihood a possibility? What is likelihood? And I would like to in this instance, Your Worship, I would like to deal with this question by zooming into the case of Bonginkosi versus the state. It's a constitutional court decision. And Your Worship, the citation is CC T27 of 2017. Your Worship, in this matter, I submit that the character of bail proceedings is two-stage. The first stage, and this is when we have to approach bail and give interpretation of sections 60, subsection 4A to E. What the court should follow, first, the court must determine factually whether the grounds listed in those sections or provisions are present. If they are not present, if they have not been established, then the applicant must be released on bail. That's the end of the debate. If it cannot be established that, because the state relies heavily on section 60, subsection 4B, that there is a likelihood that if she is admitted to bail, she will attempt to evade trial. If those factors are not established, that's the end of the debate. But if they are, one of or those factors are established, it's inaccurate to conclude that bail must automatically be refused. So there is a second leg to it. And the second approach is that there has to be the determination of the interest of justice. And what does this engage? It engages judicial discretion, which must be informed by the overall standard of the interest of justice. So in light of these submissions, the case of the applicant in this matter, Your Worship, I submit that we managed to discharge the honors to prove that the interest of justice, and in this instance, Your Worship, should the court find the schedule to be Schedule 5, the honors to prove on the balance of probabilities that all the grounds listed there have not been established by the state. Your Worship, I notice it's quarter past 11. I think I will still take the last 30 minutes and I'll sit down, I promise. I'm not sure if we can still proceed.
We can continue. What do you say? Can we just hear from all the role players here? Does anybody need a break?
No problem in continue. The clerk gives it a thumbs up. The interpreter gives it a thumbs up.
See, then we can continue.
Thank you. Thank you, Your Worship. So, Your Worship, I will deal with section 64B expansively. The argument presented by actually evidence presented by the state is that the applicant will evade trial. I don't see where perhaps they mention she will attempt to evade trial. But let's suppose they will say she will attempt to evade trial. They are basing their argument on the fact that the applicant went out of the country. Your Worship, this argument is misguided and it's not a reflection of the reality. And I've already mentioned the application that is before the High Court with regards to this, and the petition that the applicant has filed with the Supreme Court of Appeal in relation to this matter. But, Your Worship, earlier when I was making my submissions, I indicated the right to liberty, which in a way is circumscribed by certain provisions of the Criminal Procedure Act, one of which is section 60 subsection 12. Now, we are treating the risk, and this is what the legislature had in mind in introducing this fact, this provision of the Criminal Procedure Act, that in the event the state has concerns with regards to whether the applicant will evade trial, this court is enjoined to invoke the provisions of section 60 subsection 12. It's empowered. So according to section 60 subsection 12, the court can impose strict bail conditions, including the applicant being ordered to report at frequent intervals to the nearest police station. That in its own addresses this risk. We don't have any evidence before this court with regards to the applicant having any brushes with the law. So what we do have is just the issue of the applicant's likelihood that she will evade trial because of the charges that she is facing. Nothing more. In actual fact, the states showed a bit of desperation when it introduces a factor that was completely unsubstantiated with evidence, that for 11 months, and this is a naked factor, for 11 months, the applicant has been evading trial or evading justice for 11 months. In what manner, shape, or form? It doesn't come out completely from the evidence of the state. It's a standalone allegation, unsubstantiated. Submit, Your Worship, that such assertion should be rejected by this honorable court. State versus Branco is quite clear in respect of section 60, subsection 12. This is State versus Branco. It's a 2002, volume 1, SACR 531W. In this matter, Judge Kachelia A.J. held that a magistrate should consider the ties that the accused has with South Africa. As such, in terms of this principle, Your Worship, we submit that the honorable court should consider the applicant's personal circumstances as alluded to in her affidavit. Your Worship, to finish off the point around section 60, subsection 4B, I would like to also draw the court's attention to section 66. In this instance, what we do have, according to the state, is that the state has got a strong case. As indicated, they don't take it any further. They don't dispute that the applicant has strong family ties. They don't address all the provisions contained in section 66. And Your Worship, I would like to, if the court can indulge me, I would like to make reference to that section quickly. Your Worship, in terms of, I'll just get there quickly. Now, in terms of section 66, and in considering whether the grounds of section 4B have been established, Your Worship, there are 10 factors that must be taken into account. 10 factors. And I just want to locate my notes on that. Pardon me, Your Worship. Okay. All right. But one of those factors, Your Worship, is one, let me do this, Your Worship, quickly. Firstly, Your Worship, the emotional, family, community, or occupational ties of the accused in the place at which he or she is to be tried. The assets held by the accused, the means and travel documents held by the accused which may enable him or her to leave the country, the extent, if any, to which the accused can afford to forfeit the bail amount or the amount of bail which may be set. The question whether the extradition of the accused could be readily be effected should he or she flee across the borders of the Republic. The nature and the gravity of the charges on which the accused is to be tried, the strength of the case against the accused, and the incentive that he or she may in consequence have to attempt to evade his or her trial, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted, the binding effect and enforceability of bail conditions which may be imposed, and the ease with which such conditions could be breached, or any other factor which, in the opinion of the court, should be taken into account. Your Worship, what the state is relying on is paragraph G and H. But I submit that even those paragraphs, the state has not really provided this court with tangible evidence to suggest that indeed the strength of their case would lead to the applicant absconding from this matter. By the way, one would not even lose sight of the fact that there are 10 co-accused in this matter. If I'm correct, 9 of whom have been out on bail. They are facing the same charges, not similar, same. The 4 who were actually released on bail, 3 of them had to appeal, and the 4th one was released based on the new facts as a result of the ruling of the High Court. None of them have absconded. Because if we check the provisions which the state relies on, those provisions finds applicability with regards to other co-accused. The same with the next paragraph, H, the nature and gravity of punishment. They also face the same. And what we need to submit here is that paragraph A is in favor of the applicant in any event. B. C. She has no means of traveling. She doesn't have travel documents. But, Your Worship, the binding effect of enforceability of bail condition, paragraph I. We don't have a situation where the co-accused in this matter have violated any of the conditions. It is accordingly my submissions that the state hasn't established the existence of a likelihood of the applicant evading or attempting to evade trial. There is no iota of evidence. It's just allegations that are there, and the reference that I've made regarding other co-accused stands to prove that indeed this may not be a factor as strong as the state alleges. Your Worship, when you deal with section 60 subsection 4C, the state's opposition is one line. There's a possibility that the applicant will interfere with the evidence. There's nothing else. We're talking here of evidence. No evidence was presented to this honorable court to the effect that the applicant at some point made such attempts. The proposition by the state is misguided and should be rejected. I submit, Your Worship, that this factor as well has not been established by the state. Because we're talking here, the law is quite clear, the position is clear. There has to be a likelihood. A likelihood is based on evidence. The applicant, on the other hand, is saying, I have no knowledge of the identity of the witnesses that are going to be called. In actual fact, Your Worship, one will not resist the temptation of referring to co-accused because they are part of this matter. There's not been any evidence, once they are out, that there's been fiddling or attempt to intimidate or interfere with witnesses with the state's investigations whatsoever. My learned colleague can attest to that. So what we have here is, can a fear that is baseless, a concern that is not based on legal grounds, be used to in opposition of bail in respect of even this provision? Section 64C, there is no evidence before you to suggest that the applicant will interfere with the investigations or intimidate witnesses whom she doesn't even know. There's not been, the only allegation close to that is that she knows some of the witnesses. Who are they? They don't mention. But to take it further and to disrupt the chain, should it be found that, oh, she knows a particular witness, so what? If evidence is not presented to suggest that her knowledge or proximity of this witness is an indication of some sort that she will in any way intimidate or interfere. We don't have that before us. I will move to section, and in this instance, Your Worship, pardon me, I have the authority of State versus Dlamini, Lada, Jubek, Skitekat. That's the constitutional decision. In actual fact, that is the landmark decision based on considerations that the court should have on in bail applications. But, Your Worship, Section 60, subsection 4D also find no applicability. To this end, the assertion by the state is that if she's released on bail, she will undermine the, among others, bail system and everything. Where is evidence? And how, on what basis is the state relying on this, on that conclusion? Because for a conclusion to be made, there has to be a process to prove it. We don't have proof to that effect. Section 60, subsection 4E. And this is quite interesting because legislation deliberately starts with in exceptional circumstances. But in this instance, Your Worship, that if the applicant was to be released on bail, there will be public disorder. I think this point was also competently addressed by Judge Mhlambi in the appeal, bail appeal launched by the 3 co-accused in this matter. Then it was even a situation of few people demonstrating, perhaps few. But in this bail application, there's none. On what basis are we making reference to this position? On what basis? Because what we do have here is a situation where the accused is entitled because she has a right to liberty, and there's not been any public disorder, at least from where the state in its own affidavit would have mentioned it. But what the state mentioned, Your Worship, in their own affidavit is simply that there will be public disorder. That's it. And I will refer to their last paragraph. Where they are just making mention of the fact that the applicant has been appearing with accused number 5, and she appears to be showing affection to each other. They were holding hands and smiling at each other. What is the state attempting to say here? In relation to what? Is it because the applicant alleges that she was instructed and commanded to alight into a vehicle and leave the country. What does that have to do with if the applicant in that particular time, they are saying she was smiling. How does that negate what happened 4 months ago? And in what state of the mind and in what psychological state is the applicant currently? Do we know? I've submitted, Your Worship, that this is a matter that will be dealt with sufficiently during trial. What we do know now, Your Worship, is that the application, the assertion by the state to the effect that they have a strong case, the applicant says, I'm not guilty. It closes the debate. It's a matter of trial. Your Worship, I'm just about to conclude. Can I just approach my learned colleague, please? Your Worship, I've just canvassed this with my learned colleague. Just needed some 5 minutes comfort break, if it pleases the court.
Could you please just let me know when you're ready to proceed? I'm going to take a short adjournment.
All right.